I'm really pleased to be here. As you probably will see from the subtitle here, Why Our Child Criminals Owe to Break. What this talk is about something which is undeniably true, which is that child criminals are owed a break. What's a little less clear is why they're owed a break. And I should say it's one of the few fixed points cross-culturally about criminal punishment, fixed points about which people agree in many radically different countries. That is, there's radical disagreement over what we should punish, over how much punishment we should issue, over even what form punishment should take, whether it should take the form of incarceration or some other form. But what is not really under dispute is whether or not children who commit crimes should be given the same or lesser punishments than adults. And what is agreed upon everywhere, really, is that children should be given lesser punishments. In fact, I think we have a certain kind of revulsion to the idea of treating children when it comes to crime in exactly the way in which we treat adults. And this revulsion is something which is played upon, really, by this image. So this is an image by the graffiti artist Banksy. It comes from, he painted it on a wall near the town of Glastonbury. Glastonbury is known for its incredibly harsh police practices, especially towards North African teenage boys. And one of the things so this would not be an uncommon sight in Glastonbury, understood in a certain way. That is, what would be not uncommon would be to see policemen frisking children. What would be very uncommon is for those children to be little white girls with teddy bears. But one of the things that I think that Banksy was really playing on was this thought that, what you're seeing here is exactly what you were seeing when it's not a little girl there, but instead a young North African man. Now, it's an interesting fact that neuroscience has played a very important role in pushing the United States towards policies of leniency with respect to children who commit crimes, especially serious crimes. So the Supreme Court, starting in 2005, has issued a series of very important decisions, all of which takes its position in favor of leniency towards children. So the first was to take the death penalty off the table for children who committed crimes, no matter what those crimes were. It was judged to be unconstitutional, cruel, and unusual punishment to execute people who were children at the time of their crimes. The second was to remove life without parole as a constitutional punishment for children who committed non-homicide offenses. That case involved a severe rape, but did not involve anyone dying, and the defendant who was a teenager at the time, was I think 16, had been given a life without parole sentence, and this was judged to be unconstitutional because of cruel and unusual punishment. And then the third was to find it unconstitutional to require judges to issue a life without parole sentence to a juvenile, even in homicide offenses. That also was judged to be unconstitutional, and it's a little unclear what the next steps will be, but I think the trend here is very clear, and it's a trend towards leniency. Now, in each of those cases, the court saw amicus briefs written by psychologists and neuroscientists describing ways in which the psychology and the brains of children were different from those of adults. And in each of those cases, the majority opinions in the Supreme Court's opinions cited those amicus briefs, noted those amicus briefs that identified the neuroscience and the psychological science as of relevance, one of the things that were motivating their decisions. So this is an area where neuroscience has been extraordinarily influential. Now, I have two goals in today's talk. One of them is negative. I applaud the steps towards leniency in sentencing that have been taken by the Supreme Court, but I think that their reasons for these decisions have been very bad. They're making the right conclusions for the wrong reasons. And part of the reason that they're making the wrong conclusions, I believe, is that they're in grip of a false philosophical theory about what it is that justifies leniency towards children. They're making a philosophical error and that's resulting in them reaching the right conclusions for the wrong reasons. So my first goal is to try to show you why that is, what I think I'm talking about there with the negative side. The second goal is the positive side, which is that I think that we then need to rebuild on a different philosophical foundation. We have to identify an alternative reason why children are owed leniency when they commit crimes. And I'm going to argue maybe too grandiose a description. I am going to lay out a particular story as to why this is true that I can promise you, I'm about to say what it is, and I can promise you that those of you who don't know what it is are going to find it initially implausible. My alternative position is that children are owed leniency because they don't have the vote, because they're denied a say over our institutions. So when I look at this picture, what is it that is the source, I think, of our revulsion? I don't think it's that this little girl is innocent of mind or in some way disabled from fully responsible crime. I think the problem is that she's being subjected to state power over which she had no say. And that's the position which I'm going to try to argue for. Again, argue may be the wrong word. Now, one important thing to see, not all child criminals look like this little girl. This right here is a boy named Christopher Simmons. He was 17 at the time of this photograph. Christopher Simmons lived in a town in Missouri. Christopher Simmons decided one day that he was going to spend his Friday night committing murder. What did he do? Well, he came prepared with duct tape, and he drove to the house of a complete stranger, a woman named Shirley Crook. He broke into her house. He found her asleep in her bed. He bound her with the duct tape, hands and feet, and also duct tape around her head. He took her from the home, threw her in the back of his car, drove out to a state park near where he lived, threw her off of a bridge where she drowned. And he was 17. He was convicted by a Missouri jury. He was sentenced to die. This was 1993 that he committed this crime. By the time 2004 rolls around, the sentence is being appealed, the execution is being appealed, and it's the first case, Roper v. Simmons, in which the Supreme Court decides, no, you can't execute Christopher Simmons, who, understand, at this point is, about 30. You can't execute Christopher Simmons because he was a juvenile at the time of this crime. That would be cruel and unusual punishment. Now here's what Justice Kennedy, who wrote the majority opinion, said in the case to explain why it was that they were reaching this conclusion, that it was cruel and unusual punishment. He said, and actually I should say, one of the incredibly interesting things, and if anyone wants to talk about this in questions, I'd be happy to, it's an incredibly interesting fact that almost always when people get around to explaining why they want to be lenient towards children, they cite one of two things, either their experience as a parent or their experience as a child themselves. Why one's own personal experience should have any bearing on this question is a question, but here's what Kennedy said. He said, as any parent knows, and as the scientific and sociological studies confirm, a lack of maturity and an underdeveloped sense of responsibility are found in youth more often than in adults. These qualities often result in impetuous and ill-considered actions and decisions. Adolescents are overrepresented statistically in virtually every category of reckless behavior. Okay. Now what Kennedy was voicing is what is the publicly assumed position as to why children are why we ought to be lenient towards them. It's what I'm going to call the developmental view. According to the developmental view, child crimes deserve leniency because of the psychological immaturity, that is, in Kennedy's example here, diminished self-control of children. So the picture is that being young is like being mentally disabled, with only this important difference, which is that mental disability is not remedied ordinarily by simply waiting it out. But the picture is that the kind of disability from which the young suffer, disability in their faculties, diminished self-control, and a variety of other problems, are ones which they will indeed grow out of. How? By just waiting long enough. Okay. And so it's a view that says what we should be trying to do is match our punishments with the psychological capacities and the distinctive psychological features of those whom we punish. And children, as a class, have distinct psychological features, psychological features that warrant us to give them lesser punishments in comparison to adults. That's the developmental view. You're hard put to find anybody in a public forum voicing any other position. So this is when you see articles in New York Times, wherever, that talk about crimes by children, they almost invariably, we go from the first paragraph in which a crime is described and to the second paragraph in which it's noted, pick your favorite neurological fact about children. That fact is that child brains, we know, are different. And the assumption there is that the missing premise in all of these is the developmental view. What we ought to be doing is matching punishment to the degree of psychological and neural capacities, and those are different in children. Okay. Now, I want to offer you two objections. I'm going to put them in kind of abstract form, and then I'm going to try to illustrate them a little bit by talking through a recent study. I should say, both of these objections that I'm going to be voicing to the developmental view, and they may actually turn out to be the same objection, that's another further question, but both of these objections to the developmental view are inconclusive. I find them compelling. People vary in how compelling they find them. You know, Robert Nozick once said that, or wrote that, philosophers, probably everybody in this room knows this, but philosophers want an argument so strong that if you were to reject the conclusion in the face of that argument, you would die, right? So now this is not, what I'm going to be offering are not objections of that kind. You can survive and hold on to the developmental view in the face of my objections. But what I want to do with these objections is to pry you away from it and prime you for an alternative. Okay, so the first problem, as I see with the developmental view, is what I'm going to call the precocity problem, which is that under the developmental view, children who are precocious, that is, who are ahead of the curve developmentally, are owed no leniency when they commit crimes. Or, now this I think is just simply not true as a matter of moral fact. That's the part that you might reject, but that's what I think. So that is, or another way to put this is that the developmental view misclassifies an act of leniency towards a precocious child as a false positive. We're trying to identify which people are warranting of leniency. We use age. If you're under 18, you get leniency. And then the developmental view says, yeah, but if you are developmentally like somebody who's 22, then we're actually wrong. We're making a mistake in classifying you, the 17-year-old, as somebody worthy of leniency. So it classifies that as a false positive. And it might be a false positive you can live with. You know, maybe in the end it's better to be lenient to people who don't deserve it. But nonetheless, the developmental view has to classify it as a false positive, and I think that's an error. I don't think it is a false positive. I think Christopher Simmons, who actually, by a lot of measures, is probably pretty precocious. By a lot of measures, I think that actually leniency was warranted towards him. Not no punishment, but less than whatever would be warranted for an adult who committed the same crime. And that's something which the developmental view actually can't accommodate. So it's actually a kind of peculiar irony, I think, about the Supreme Court's opinion in the Christopher Simmons case, that they cite immaturity in order to justify leniency towards Christopher Simmons, whom they have no reason whatsoever to believe is actually developmentally behind the curve. He actually might be way ahead of it. Okay. That's the first problem. I'm going to be illustrating this in just a second with another example. The second is, and I think very closely related, is what I'm calling the problem of empirical dependency, which is that under the developmental view, an ideal policy about who gets leniency and who doesn't, an ideal policy would be tailored to the empirical evidence about development. So if we had classes of people who we had reason to believe were just like fully developed adults in their capacities, the best policy would be one that that denied them leniency. Just as on the other side, if we had a tool for identifying adults, those over 18, who we had every reason to believe were more psychologically like those under, like the average under, that the better policy would grant leniency to them. That is, the policy should be tailored, if it's ideal, it should be tailored to the empirical facts about the psychological capacities of different groups of people. And the thing is that, in fact, and this again is just an intuition poll, but in fact, we tend to be highly averse to a whole variety of different ways in which we might tailor such policies. We prefer the policy that grants leniency to all the children to ones in which were so tailored. So the most obvious example is when it comes to gender or to sex. That is, girls do indeed mature faster than boys. On every developmental measure that you find, practically, of psychological capacity, you find that the 16-year-old girls look a lot more like the 19-year-old boys. And so we have actually a really easy way to tailor our criminal justice policies if what we were trying to do was tailor them to match degree of developmental ability. Just be a lot harsher to the girls than to the boys. Or make the age of maturity for criminal law purposes for girls, say, 16. That would actually get us closer towards matching with the facts about development than we currently do with the policy that gives a break to everybody under 18. So if we're averse to that policy, and I think we are, what should we learn from that aversion? What we should learn from it, I think, is that what's motivating our adherence to leniency towards children is not their development. Okay? I'm going to try to illustrate this point also in a little bit of detail shortly. Make sure I'm not way off on time. Okay, so first a quick note on precocity before I move more into empirical dependency. So probably, I imagine that most of you know about the super predator classification. So this was the 1980s. Yeah, I don't think West Wing was on yet. So it was the 1980s, and there was a guy named John Iulio. Iulio was a criminologist. He reached the conclusion that there was a large growing class of teenage boys whom he labeled the super predators. And he thought that these were a very precocious class of people. They were precocious in all the ways that we find deeply frightening when it came to violent crime. They were precocious in their criminality and in all of the particular sets of capacities that one would need to be an extremely effective adult criminal. They were acquiring those capacities early, in their early teens. And he said, look, there's this class of people. And he thought he had demographic information to suggest that it was growing, that class of people, radically, very, very quickly. And that if we didn't do something to stem the tide, we were going to be collapsing under an avalanche of violence perpetrated by these young boys who were going to become young men. And there was going to be even more of these young boys, okay? This is what Iulio thought. And he propagated this view, and it was accepted in many circles. And one of the results was that the criminal justice system in the United States became far more punitive towards teenagers than it had been previously. So it resulted in a huge increase in transfer, that is, of movement of trying children as adults in adult court for especially violent crimes. It resulted in much greater and more severe sentences for children sentenced at all levels, whether they were sentenced in the adult system or in the juvenile system. And there was this is now viewed in most circles, and it was even repudiated some years later by Iulio himself, it just turned out to be a very, very bad theory. And there's two very well-known criticisms of the theory. Iulio's was the second that's here on the slide, which is that what Iulio discovered some years later was, oh, my bad, there actually aren't really very many people like this. Not nearly as many as I thought there were, and there wasn't actually a very good reason to think that the group was growing. Okay? There was this other problem, and this is the one which came to bite Hillary Clinton in her use of the term super predator, which was that it turned out that when people actually sat down to classify particular defendants who had done bad things as either super predators or not, that they threw all of the black boys into the category of super predator and threw everybody else into the category of far less dangerous. So that is, it was just a radically racialized category. You applied, straightforwardly racist in its application. There isn't any dispute about that now. And now notice, these are good criticisms of the super predator story. But notice something about the super predator story, which is it became attractive to people precisely because they accepted the developmental view. It was precisely because they thought, why do you warrant leniency as a child? Because you're not precocious, because you're normal, and normal kids are in this way disabled. They don't have the same kinds of capacities for self-control and so on that adults have. So if there's this class, this special class of kids who aren't like that, who are precocious in that respect, we shouldn't be lenient towards them. We should treat them exactly the same way we treat adults. That was the appeal of the superpredator theory. And the mistake was, and so if you adhere to the developmental view, you rob yourself of one particular form of criticism of the superpredator theory, a form of criticism which I find in myself anyway very, very compelling. And that's the third one here in red, which is that even a kid who was a superpredator, even a kid who was actually psychologically precocious as a precocious criminal, would be deserving of a break. And we rob ourselves from that form of criticism of the superpredator theory. That is, I think we should have said to John Iulio, too bad that there's going to be this large group of people who are very, very dangerous. We have very good reasons not to punish them as harshly as adults anyway. But we can't say that if we're holding on to the developmental view. This is just a special version, a special application of what I'm calling the precocity problem. Okay. So now what I want to do next is I want to talk through a recent study done by, this comes out of the lab of Larry Steinberg, who is one of the most influential developmental psychologists. So he's in the et al. Here, because, wow. So I pick it actually for several reasons, but one of them is that this comes out of the Steinberg lab, and the Supreme Court keeps repeatedly citing data out of the Steinberg lab. And I actually think Steinberg is doing fantastic science, but I also think the kinds of conclusions that are being reached on the basis of that science are in error, and they involve making the mistake that is revealed, making the mistake of accepting a developmental view, a mistake which you can see by thinking about the problem of empirical dependency. So here's what they did in the study. And I should say a further follow-up study was done where they scanned people's brains while doing this, and I would have the same criticisms of the more complicated neural version of the study. But here's what they did. So they bring you into the lab, you're going to be a subject in the study. They say, here's what we're going to do. We're going to show you, you're going to have a button in your hand, okay? And we're going to show you these faces. They're going to come up like this in order, in some random order. And they're only going to be there for a second. I don't know exactly how long, but very small amount of time. And when the face is there, you're to press the button. But only press the button to calm faces. So you're to hold off from pressing the button for this frightened face, hold off from pressing the button for the happy face, only press the button when you see this calm face. And the faces come fast, right? So you're like, so you have to make this thing. It's a standard kind of self-control sort of a study. People who are good at it make a quick determination and control themselves to hold back from pressing the button for the wrong kind of face and press it correctly for the right kind of face. But there's a further twist, which is that sometimes you're going to have a frame around the image that's in this light blue. And when you have a frame in that light blue, you're wearing these earphones, who knows when, but it might be the case that you're going to get a really, really nasty noise blaring in your ear, and it's nasty. I actually looked for a recording of it. I couldn't find a good one, sorry. But it was like, I heard it once. It's like this really, really unpleasant thing, and it screeches in your ear for an extended period of time. And when you see that blue frame, that might happen anytime. Similarly, but on the other side, if you see this purple frame, you might hear a different kind of noise. You're going to hear a little cha-ching at some random time. And what that's telling you is that at the end of the study, you're going to get some extra money. Okay? So this one is a kind of state of threat. And this is a state of potential reward, an excited state, but positive. And then they also run it for a state of neutrality, where you're not expecting any particular kind of sound, either telling you of a coming reward or of something that's really aversive. All right. And then they have people doing this, and they divide them into three groups. The teens, who are 14 to 17, the young adults, who are 18 to 21, and the people they call adults, who are 22 to 25. All right. Now here's what you get. So on this axis here, this thing called D prime, that's a measure of how good you are at the task. It tells you how many errors you make and things like that. Okay? So here's what they have in the state of neutrality, which is that it looks like people get better and better at the task as they get older. This is the standard development that you see, development in a certain kind of self-control ability tapped by this task. And what this little asterisk here is telling you is that the only statistically significant result they have here is they see a difference between the adults and the teens. The young adults for all they know, are not really different from the teens. But it's also true that for all they know, the young adults aren't really different from the adults. You don't have a statistically significant difference between the one in the middle compared to either on the other end, but you do have a statistical difference between these two, okay? So this all by itself is the kind of study, this actually replicates something which has been done many, many times, trying to show that self-control is something that you develop through normal development. You get better at it, okay? And then they have this other result, another interesting one, which is that if you look only at the state of threat, everybody gets a little worse at the task. You can see this is almost 3. Here it's a little lower for the adults. Everybody gets a little worse at the task when there's this possibility of the nasty noise in your ear. No surprise. But what's interesting is that the young adults get significantly worse at the task, so significantly worse that now the difference between them and the adults is statistically significant. That's what that's telling us. Okay? All right, that's pretty interesting. Seems like exactly the kind of thing, in fact, it is exactly the kind of thing, that Kennedy has in mind when he reaches the decision that he reaches in Roper. Look, this is the sort of thing we know. Kids get better at self-control. Okay. So now, what's going on? Let's just look at the results in the state of threat for a moment. Now, there's a really hard question. I don't have an answer to it, actually, as to why it is that this degree of the degree that's measured with this thing d prime, the thing that's being measured by that, whatever skill it is, why more of that should make you more eligible for criminal punishment. I don't know that it does. We could talk about that. But let's assume for a moment that it does. The better you are at this skill, the more worthy you are of criminal punishment. So the picture must be that there's some threshold where if you're above it, then you're worthy of adult criminality, adult criminal responsibility, adult criminal punishment. And if you're below it, then you're worthy of leniency. That's the only way we get a result like this to support the claim of leniency. So where do we want to put that threshold? I don't think we would want to put it all the way at the average for adults. It's not like every below average adult is deserving of leniency. You can be quite a bit below average and be worthy of punishment, right? So it's going to be somewhere below that. So let's pick it at like a standard deviation. That puts it there. Okay? So the picture is, look, you're above a 2, then you get full punishment. You're worthy of full punishment. Below that, you're compromised. It's like a measure of like IQ or any other kind of measure of disability. So now let's actually look at the data that gets pooled into these bars and put that same bar in. Okay? It's a lot messier than the little graph made it appear. Right? Because what do we have? What we have is that there's actually, like, look, there's a 14-year-old right here, 14-year-old girl. She's performing above that threshold, okay? And she's performing better than, like, all these people, including this poor 25-year-old who just sucks at the task, okay? Now, it's also true that you are seeing improvement. It's not like you're not. This is a discovery. I mean, it's a discovery of empirical psychology. It's worthy of publication. It's a great study. You are seeing improvement over development, right? You don't have anybody, no 14-year-olds up here, right? But you really have a lot of variation. Now, what should we conclude? The authors of this paper, actually, I want to draw your attention to one other thing before I ask what you should conclude. If you just look at the 14 to 18s in this quadrant above the red line, not a lot of boys in that group. There's a couple, but it's like, I think I counted these numbers. I think it's like 10 to 4 in their group. There's 10 girls above that line, 4 boys below it. But you also find some other weird things when you start taking gender seriously. There's a lot of boys in the 18 to 21 range who are really good at this, under threat. Maybe we should call them the super predators. Okay, so now, what conclusion should we reach from this? Well, so the authors of this study claim that their results support leniency towards kids who commit crimes. But notice just a little bit of reflection on that little scatter plot tells us there's some other conclusions you might reach. I mean, don't the results also support denying leniency to those kids who are above the line set by adult normal performance? And don't the results also support treating kids who commit crimes under threat pretty much just as harshly as kids who commit crimes in neutral circumstances? Because in fact, we don't find any real difference in their performance, not a statistically significant difference. Here's what's really going on. The reason that these people, who are very smart people, top-notch scientists, doing really important work, the reason that they are willing to reach the normative conclusions that they are, that these results support leniency, that those are the ones that's what they report, is because they already believe in leniency on separate grounds. The empirical result isn't justifying the leniency. Rather, adherence to the normative position is what's guiding the interpretation of the experiment. And so where does that leave us? Where it leaves us is that we have to look at some alternative to the developmental view. We have to have some other philosophical reason for thinking that we ought to be lenient towards children. Now, there's two possibilities, and I actually really mean this, two possibilities. I adhere to the second, but I don't have anything which rules out the first. It's possible that the reason we think we ought to be lenient towards children, that we actually don't have no reason for that it's a non-rational attachment. It might be very easy to construct evolutionary explanations for why we should be attached to that, why we should be averse to the harshest of punishments towards children, not for good reasons, or anyway, not for the kinds of reasons which would serve to rationalize that practice. That's one possibility. The other possibility, and this is the one that I want to spend what time I have remaining trying to flesh out, is that there's an alternative argument, that there's an alternative thing which justifies our leniency towards children. And that's where I'm going to draw on this idea of political representation. That is what I'm going to try to now explain briefly, and too briefly, is what I call the disenfranchisement view. That is, the child criminals are owed a break because they do not have the vote. Or put another way, say that two people, A and B, are behavioral, neural, and psychological twins. But A has the vote, and B does not. So the only way in which they differ is in where they stand in political arrangements. Then I claim that B is reduced in culpability for his crimes and is deserving of lesser sanction. The political arrangements that account for who gets the vote and who doesn't make a difference to the facts about culpability. How could that be? How could that be? Well, it turns out to be an implication of a theory of culpability that I've been developing for a while and trying to apply to the criminal law context, but which has close connection to reasons responsiveness positions in the free will debate. So here's the idea. What is it to be criminally culpable for a wrongful act? Well, the proposal is that what that is it's to manifest in one's wrongful act a failure to properly recognize, weigh, or respond to the legal reasons that one has to behave differently from the way in which one actually behaved. The manifestation of one's particular way of responding to reasons, that's what it is to be culpable. So for instance, to use an example we were discussing actually yesterday, X runs a stop sign with the intention of killing a pedestrian. Y runs a stop sign to get to work faster while aware of a 10% risk that a pedestrian will be killed. Same wrongful act, different degrees of culpability. That is, it's way worse to do the thing intentionally. Why? On the theory that I'm proposing, the reason is this. Imagine a scale. This is how much reason-giving weight. This is a scale of reason-giving weight to a particular fact about one's action of running the stop sign, which is that it might kill somebody. There's somewhere on this scale is no weight, treating that fact about the act just the same way as one treats the fact that the pedestrian is, a redhead. Totally irrelevant to one's decision, okay? There's some degree of required weight. We have to actually give not no weight and not positive weight to the fact of the prospect of death, but negative weight to the prospect of death, if we're to be what? Fully functioning proper citizens who take seriously our obligations to one another. We have to be highly averse to actions that contain the possibility of killing another person. Now, then you can think of, so whatever the required weight that one must place on that is, and it's not unlimited, right? We're allowed to go driving, fully recognizing that we might kill people. So it's not that we have to make that just decisive. If ever there's that prospect, we can't do it. We're allowed to discount that to some degree, but how much? I don't know. Let's call it the required weight. If you, in fact, are averse to that at that level or below, you're faultless. Okay? I shouldn't have put oblivious there, actually, sorry. If you are sufficiently averse that you're below that threshold, you're faultless. That's why we're in blue. As you have various kinds of psychological states that motivate your conduct, we find that those psychological states result in the manifestation of different degrees of weight being placed on the prospect of death. So if you intend to kill, you place a lot of positive weight on that fact. The act is actually attractive to you in virtue of the fact that you might kill somebody by doing it. Where if you're merely aware of a 10% risk of death but are just trying to get to work, you might be a little bit averse to it, but not as averse as you ought to be. Because you ought to be so averse to it. You ought to weight that fact so strongly that a 10% risk is going to keep you from running that stop sign. Okay? And maybe 80% is somewhere in between. I don't know. Maybe to get yourself to actually do it, if you think there's an 80% chance you're going to kill somebody, maybe you actually have to grant it positive weight. Maybe you have to think it's at least a little bit attractive, a little bit exciting. I don't know. Okay? So the idea is that psychological states like intent to kill or awareness of risk, why do these matter? Why do these matter to degree of responsibility? They matter because they're markers of the way in which one treats legal reasons. Okay? So now notice something. Whether or not you're culpable, that is in the red zone here, and so criminally culpable, is going to depend entirely on where this line is, the line of required weight. And notice something else, which is that weight, that requirement varies with legal and political facts, not just with facts about psychology. So let me give you an example. The state of California has an ordinance, statute, which makes it a crime to defraud a pawnbroker. It's a different crime from a crime of fraud, generally. Anytime you defraud another person, you're guilty of a crime in California, like every other state in the union. But if you defraud a pawnbroker, you're guilty of a distinct crime. So it would, for instance, be an excuse. So if you show up in court, you've defrauded a pawnbroker, you get excused if you prove that you had no idea the guy was a pawnbroker. That would not be an excuse for general fraud, but it is an excuse for fraud of a pawnbroker. What does this mean? It means that in California, you're actually required to be averse to an action, to the action of defrauding another person, averse to it more if the person you're talking about defrauding is a pawnbroker. That's not of moral significance whatsoever, right? Fraud is fraud. Fraud's wrong, but it's not worse when you do it to a pawnbroker. So what is going on? What's going on is that your legal reason, the legal reason given to you to refrain from the act, is dependent on a particular, I wouldn't say arbitrary, but a particular legal fact that a statute says it's illegal to defraud a pawnbroker. Okay? That legal fact makes a difference to what you are required to give reason-giving weight to. So if you ask, where's that line? The line of how much weight you're required to give to the fact that a person is a pawnbroker? In California, that line is such that you need to be averse to performance of the act, additionally averse to it, on the grounds that that person is a pawnbroker, in a way that you're not required in Oregon, or for all I know in Iowa. I meant to look this up in Iowa, but I didn't. A lot of states have this, special protection of pawnbrokers. Okay, so that's a kind of warm-up point. It's to point out that where we place the line for criminal culpability is not just a matter of morality, it's also a matter of legality. And legality is, as in very familiar ways, a product of political arrangements. Okay, now, whoops, I just said this already, sorry. All right, now, how does this have to do with the vote? Well, the vote, I claim, the way in which we allocate having a say over the law, itself makes a difference to the strength of the legal reasons that people have in a very distinct way, which is when people have the vote and therefore have a say over the legal arrangements, they are actually now complicit in an important way in the strength of the legal reasons that apply to them. They're a contributor to making it the case, to its being the case, that there is a legal reason of a particular strength with respect to them. Roughly speaking, the more say you have, the more it is the case that you bring it on yourself when you violate the law. And that, I believe, tells you something about what the strength of the legal reasons are. And thus, it matters to where we place that bar about how much weight you need to put on particular facts. If you have a say over the law, you need to place greater weight on the particular facts that give you legal reason than if you don't have a say over the law. Okay? So, if you have a say over the law, now who has a say and how much say they have is clearly a function of political and legal arrangements. We could have set things up so that all the children vote, but we haven't set things up that way. So how strong your legal reasons are is a function of the political arrangements that allocate the having of a say. And what that means is that what the bar is for culpability varies depending on whether or not the particular offender in question had a say over the law. Two people psychological duplicates. What does that mean? It means that they place the same degree of weight on particular facts, like say, for instance, the prospect of death. It doesn't follow that they're equally culpable, however, because they might be different distances from the requirement about how much weight to place on those facts. And if they're different distances from the requirement, they will differ in culpability in the same way that people differ in culpability when, for instance, they intend to kill, or as in contrast to having other psychological states. Okay. Now, how am I on time? Do I have a couple minutes? Okay. Now, what you can see is that this way of thinking about it, this account of culpability, actually I should say just first, just a tiny bit more before I summarize here, a tiny bit more about what it is to have a say over the law. I actually think that the crucial concept, I like to summarize my view here by saying children are owed leniency because they don't have the vote. But in fact, what I really think is that children are owed leniency because they have reduced say over the law. And the vote is just one mechanism through which we institute what it is to have a say over the law. So what is it to have a say over the law? My proposal here is that it's to have a pair of entitlements possessed in a particular social condition. The entitlements are that you have to have an entitlement to exert influence over the law. And actually what I mean here is a legal entitlement. The law has to grant you an entitlement to exert influence over it. You also have to have an entitlement to be free of a variety of obstacles to exerting that influence. So for instance, you're entitled not just to cast a ballot, you're entitled to have a polling place, to have some mechanism through which you can cast your ballot. And further then, there's also a further actual fact. So these first two are normative facts, facts about entitlement. The third is a fact about the conditions in which you find yourself, which is that you have to be in fact free of the obstacles that you're entitled to be free of if you're to actually have a full say over the law. And what we find when we start to look is that there's variation among people in these particular qualities. So for instance, children don't have an entitlement to exert influence over the law through the vote. They do have some entitlements to exert influence of the law through the exercise of free speech. Those entitlements, however, are quite limited in comparison to those of adults. For instance, parental control governs. So your parents can prevent you from attending political rallies and be supported by the law in their desire to keep you from those rallies. But no such similar thing, you wouldn't get a similar kind of legal support for the prevention of other adults from attending those rallies. So the vote is one of the mechanisms through which we give people a say, and it is one of the primary mechanisms through which it is denied to children. Okay, so the full dress view then is just this in set of premises. Children have less say over the law than adults. So they're less complicit in the laws dictating punishment for crime than are adults. So their legal reasons to refrain from crime are weaker than those of adults. So children who commit crimes are reduced in culpability in comparison to otherwise identical adults who commit those crimes. Why? Because they're closer to doing what is required of them when it comes to the granting of weight to legal reasons than are adults. Why? Because we moved the bar, not because we changed their psychology. I think it's a fixed point of discussion here that punishment should be proportional to degree of culpability. That's the fifth premise. And the conclusion is that kids who commit crimes are owed a break. What's missing from this list, and I think a good thing, is a developmental premise, is a claim to the effect that children are a disabled group. Okay. Many, many challenging questions left unanswered here. Many, many challenging questions left unanswered. And I don't, in any sense, claim to have answered all of them here, by any means. Just to identify a few. Don't we deny the vote to kids because of their psychological immaturity? If that were true, then I'd be offering just a version of the developmental view. I don't think that's true. But I can explain why in questions if people want to talk about it. Another question. How much say over the law does anybody actually really have? Like, not a lot. You know? I mean, even those of us living in ivory tower institutions with many, many advantages in life don't have really much control over what the law turns out to be. What about other non-voters? This is prisoners, felons, visitors, immigrants. There's many, many, many people to whom we deny the vote. Are they also reduced in culpability? The answer is kind of depends. And then another example, another question. Shouldn't there be a difference in criminal liability between adolescents and small children? Isn't there really a difference between Christopher Simmons and some like 9-year-old? But they're equally denied the vote. So how should I think about that? These are just 4 examples of really hard questions about which I have things to say, which vary in their degree of satisfactoriness, I'm sure. Okay, I want to identify quickly 3 practical implications. 1, the fact that one person is under the voting age ought to mitigate sentence regardless of one's degree of maturity. You don't need a finding to the effect that Christopher Simmons is actually compromised in his capacities for self-control or some other set of capacities to think that he's going to be worthy of leniency in comparison to an otherwise identical adult. You don't need to think that on the view that I'm proposing. A second, juvenile transfer to the adult system, assuming that juvenile systems are more lenient than adult, which is actually a very complicated question, whether that's true. But assuming that, in my view, this should be the end of transfer. No child should ever be transferred to the adult system, regardless of their maturity or the severity of their crime. I think that's always a philosophical error. A third, raise the age movements. I don't know if you're familiar with these at all, but there's movements afoot in several states, largely in response to empirical results like the one that I talked through out of Larry Steinberg's lab, which say that we ought to be raising the age of criminal liability, of full criminal liability, from 18, which to, say, 21. 21 is the most commonly offered one. So that we should be treating 20-year-olds as juveniles. I don't think we should be doing this. I think that this would catch us in a certain kind of incoherence unless we're also willing to raise the voting age, which is a possibility, but in fact we seem to be going the other direction, mostly on voting age, which is to lower it. And then a quick point, which is, how does empirical work on kids bear on their criminal culpability? One real observation about this, which is finding out that a group of people, identifiable by an easily identifiable characteristic like age, that they tend to have a particular psychological or neurological feature, like diminished responsibility, like diminished self-control, or easily influenced by peers, that provides evidence that a particular person in court also has that feature. And if that feature indeed mitigates, then that provides mitigating evidence. This is true for everybody of all age groups. It's not distinctively true of children. Okay? So the kind of developmental work, like the example study that I talked through, they're finding something of interest. If you really think that that kind of self-control matters to responsibility, then you ought to think that a study like that provides evidence that the 14-year-old before you in the courtroom is diminished in self-control in a way that might matter. You need to make the further step of thinking that that 14-year-old, the one sitting there, actually has the deficit, which is typical of their group, in order for you to then reach the conclusion that they should be mitigated in their responsibility on those grounds. So that is, this doesn't support, so that the current work is useful fodder for the criminal justice system, but it's not sufficient, because it's not giving us sufficient grounds to be mitigating across the board for children. Okay. And then just to say, so there's lots and lots of questions. I haven't answered them. I try to answer more of them in this wonderful book, which you should all buy. So I will stop there. Thank you. let's use the microphone.
Okay. So I was thinking about the questions you don't have like super good answers for, and I thought of numbers 2 and 3 on that, and like the level of importance you have place on people's like rights necessarily, because like if someone's gonna be like, I really want to murder someone, let's legalize it. No one's gonna listen to them. And then also like I was thinking about felons, but I feel like asylum seekers actually make a better point. So do you like have responses to those even if they're not like super well?
Yeah. So actually, take the no one's going to listen to them point. So I went by this kind of fast, and I didn't really highlight something that's important about it. But take a look at what I say about what it is to have a say over the law. I think it's pretty kind of like plausible. I don't know, these 2 entitlements in this actual situation. Nowhere in there does it say that to have a say over the law, you need to actually have any causal influence over the law. Okay? And that's how it should be. So I am mortified about my nation's performance in Guantanamo Bay, like genuinely mortified about that. I'm upset, but not mortified by the behaviors of many governments around the world. Why mortification about Guantanamo Bay? Not because I had any causal influence over the decision to make that prison or to keep it going or any of the decisions. I have had 0 causal influence over it. So why am I mortified? Why am I implicated in it? Why am I complicit in it? And the answer is because I have certain kinds of entitlements to exert influence over my government's behavior. Entitlements which actually, as a matter of causal impact, are of no use. But nonetheless, I have those entitlements. So this is complicity by entitlement. And that's, I think, true of everyone at the day that they reach 18, despite the fact that they don't have any causal influence over the law. So that's, I think, the main point. On this other point about asylum seekers and so on, so my general, where did that go? So here's the way in which I'm thinking about, so imagine a conversation between child defendant and judge over sentencing. So the judge says, adults in my courtroom get 5 years for this burglary. I'm giving you 5 years. And the kid says, but I'm just a kid. And then the judge says, well, why does that matter? And the kid says, well, it's not my law. In what sense? In the sense that I'm not complicit in those legal demands that you're making on me. I'm not complicit on them because I don't actually have an entitlement to exert influence over them. And the adult does. That's the difference between me and the adult. Okay? And the kid has a point. That is, the kid is saying, it's a form of the point, not my law. So everybody gets mitigation, provided they can say, not my law. My view about some of these groups, notably visitors and immigrants, maybe asylum seekers too, is that they are barred from saying, not my law. They're barred from saying it, even though it isn't their law. Okay? This is analogous. I mean, the kind of like really simple-minded example. You know, you go to the house and they say, we all take our shoes off here. If your answer is, not my rule, something's gone wrong, right? Well, it's not that it isn't your rule. So why aren't you allowed to say that? We need a story, something, but that's some kind of story there is the sort that's going to explain why it is that we shouldn't be mitigating punishment for visitors who commit crimes on our soil, even though we should be mitigating, despite the fact that they don't have the vote. Asylum seekers, I think, are an even easier case, actually, asylum seekers are an easier case, but cutting in the other direction. That is, one of the crucial things, I think, probably, about why you're not allowed to say, not my law, is because something else is your law. You have another legal home. And part of the reason you're leaving it and visiting, and that's part of the reason why you can't say while you're visiting, not my law. And the thing about the asylum seeker, if they actually have a claim to asylum, is that they're nationless. And so they actually might be able to say, not my law, because they have no law anywhere. But this is less well worked out than I would like.
I'm sure you've heard a version of this question before, but now you're going to hear it again. I
can't wait.
So there are just over 500,000 people in Wyoming, and they have 2 senators. California has 39 million people, and they have 2 senators. So are people in California owed leniency in criminal cases because they're underrepresented in the political system?
Yeah, so one of the interesting things about degrees, one of the peculiar things about a representative system of government is that how much say you have is not simply a function of the number of voters in a pool that are over the relevant decision, right? So there's various ways. There's a problem here that's analogous to the equality of what problem in the equality literature. Why is it, maybe not even analogous, maybe it just is that problem in a slightly different form. Why is it that there's equality of say over the law between the California voter and the Wyoming voter? The answer is they both have 2 votes in the Senate. Now, that's to answer the equality of what question? Oh, in order to have equality over that, what you have to have is a representative, the same number of representatives in the Senate. Why isn't that good enough, right? But one of the strange things, so that's the answer to your question. That's why it is. They actually have equal say. But that why they have equal say comes with a particular theory about what it is to have a say, which is telling us that what's relevant for equality when it comes to senatorial representation is just the number of senators and not the size of the pool that's contributing to the choice of who's in it. Now, the strange thing, of course, is that in our representative government, we're going to have a different metric for equality of having a say when it comes to the House of Representatives. You only have the same number there if roughly it's the case that the pool per person in the Senate pool per person in the House of Representatives is the same size, right?
But is your leniency just a threshold concept? You either get it or you don't. There's not a matter of degree.
Oh no. So I would want it to be a matter of degree, actually. And so what's going to mark it as a matter of degree is one's degree. If these entitlements of that are involved in having a say come in degrees, then so will criminal culpability come in degrees which are sensitive to those. What's interesting about the vote, in particular, is that it doesn't come in degrees. It's an on-off switch.
So could you please answer 1? Because that's the question I had in mind the whole time, that you were just sneaking in the developmental view, right? That it is because of some sort of a version of developmental view that we do not give children the right to vote.
Yeah, so here's something I think that, when I started thinking about this project, I thought that was the first objection that I came up with. I thought this is decisive. This is just the developmental view again. So here's the thing that I can tell you how I became convinced that actually wasn't the case. So I actually looked this up about the state of Iowa before I came. So take the case of, occasionally it's the case that adults, various people in an adult's life, want that person to stop being on the voter rolls. And every state in the union has rules that you can satisfy, which if you satisfy them, you're going to be stripped of the vote as an adult. So for instance, California, you can be stripped of the vote if you can't fill out a voter registration card on your own, unassisted. Okay? Voter registration card requires your name and where you live, and that's about it. So what they're saying in having that law is that anybody who can fill out a voter registration card is sufficiently competent to get the vote. Now notice something. I had a pretty precocious kindergartner. She could totally fill out a voter registration card at the age of 5, okay? Right. And there is barely a 10-year-old in the nation who can't do it. Similarly, so Iowa, interestingly, has something that's actually more typical in the nation, which is that in order to strip somebody of the vote, they need to be showed to be incompetent. But then Iowa defines incompetent as not understanding what it is to vote. So that's what's going to happen is you're going to actually have somebody examine the person and say, do you know what it is to vote? And they're going to give you a definition that roughly matches what voting is. And if they can do that, then they're sufficiently competent. Again, a lot of 10-year-olds are over this bar. So what does this tell you? It tells you that at least who you're going to deny the vote to is not just a matter of incapacity. Or if it is, it's bizarre that we're setting the voting age at 18. Why not set it at the day that you can that you can fill out the voter registration card, or the day that you know what it is to vote? That is, it looks like something else is going on. So here's what I think else is going on, and it again is a more complicated story. But what I think is going on is two things. I think that the decision about who gets to vote and who doesn't, I think that this is a compromise between two competing values. So on the one hand, if you grant the vote to children, to like 7-year-olds, together with maintaining our laws allowing parental control over children in a whole variety of different ways, then what's happening is that you're granting an extra vote, extra say over the law to parents in contrast to the childless. Because what you're giving parents is an entitlement to control, to exert influence over the law by exerting influence on their children's voting behavior, which would be a way, and it's not just a causal impact, it's an entitlement, because we have entitlement to control our children and to influence their values in a variety of ways. So what that mandates against is that considerations of equality point us away from giving the vote to children, since there are a lot of childless people in the world who should have equal say over the law to those who are parents. But the problem is that if we were to deny the vote to every child always, forever, never to be acquired, that would be the end of the republic. Because what the republic requires in order to persist is that new people gain the vote. And so that mandates setting up the vote, getting people to achieve the vote at some point or another at some point or another along the way. Where have we picked it? 18. 18 is a very interesting age because two things happen at 18. You get the vote, and your parents get stripped of many of their legal entitlements to control you. Two things right on the same day. So what's happening there? You're getting the vote, and we're obviating the equality problem by taking it away from parents, their entitlement to exert influence through their children. So that's the kind of story that I want to tell. It has nothing really to do in the end.
No, I see that, but the reason why that all happens at 18 is because, again, perhaps the developmental view, because there is the subtext is that is a certain level of maturity is reached at that point.
So
right?
I think you're right about one thing, I think, absolutely, which is that 18, as opposed to 16 or whatever, where all these things would need to line up, that looks like it's probably a developmental choice. Right. I think that's probably right. I think that, however, that isn't really the developmental view, because what it's not saying is that we're choosing that because you attain at 18 certain degrees of competence. I actually think what we're doing there, really, is that we're saying to parents, you got about 18 years to influence your child's values, and then all bets are off. And it's kind of a reasonable place to put it, because you're going to have limited control over their values past 18 anyway. That is, if there are developmentally relevant facts here, they're not ones like about self-control and things like that. They're about the formation of values and the way and the parental role that parents play in the formation of values. So it's not that no developmental science is relevant to the choice of 18 as opposed to 16 or 19 or whatever. It's that it's a different body of developmental evidence, and it doesn't really have much to do with competence to wield the vote. See what I'm saying?
I'll follow up later. Yeah.
That's the best I can ever hope for, honestly. So
you talked about the case of visitors and immigrants and asylum seekers from number 3, but what I'm really interested in is the felons case, right? Because I can kind of see the point that visitors and immigrants have done something, they've come here and made themselves subject to the law, analogous to your case of coming to someone's house. But with felons, the state has said, no, you do not have the option to exert anything over the law. And that seems to lead to this bizarre result that the felon can say, I'm going to go commit a bunch of murders and I have reduced culpability because not only is it not my law, but you made it not my law.
I couldn't agree with you more. I think we're tied up in incoherence to the extent that we deny felons the vote. And I wouldn't rest with felons. I would say that also of prisoners. And so this is, so David mentioned, publications of mine in the Washington Post. That's one of them. It was an op-ed specifically on this issue, basically making exactly the argument that you did, but in the contrapositive form. That is, what I think is, because we have powerful need to hold recidivists fully responsible for their crimes, to not grant them leniency, we need to also give them the vote. And I think we lose our rationale for treating them as we currently do, as fully responsible adults. In fact, is even having exacerbated or increased criminal culpability while we deny them the vote. That is, my main point is a coherence point. It's incoherent to deny somebody leniency while also denying them the vote. And that's precisely what we're doing in the case of felons. Now, in the case of children, I think we have good reasons, that there's the ones that were just brought up, for denying the vote. In the case of felons, we don't have any good reasons for doing that. And so we're actually tied up in incoherence to the extent that we continue to punish them as harshly as we do for their recidivist acts. That, to me, what's the remedy? Give them the vote.
Yeah, so I agree with you about the remedy, but in the meantime, until those things are required, are you saying that in sentencing, regardless of what crimes they further commit, they should be given leniency?
I am saying that. I am saying that. That is, there is a very important sense in which they are like Banksy's child against the wall, being subject to force that over which they do not have authorship. And that is, I believe, is a form of tyranny. So I think we are, in fact, engaged in a form of tyranny with respect to those felons to whom we deny the vote while giving them full helpings of punishment.
So I also had a question about the developmental view. So one of your the primary reason you rejected is what you call the precociousness problem, is that right? And so can you go back to that? I just want to.
Sure.
So basically you give all these reasons and then. And in the end they say, but they are, right? So no, so you say something like, under developmental view, precocious children are owed no leniency when they commit crimes, but they are. And I want to question, but they are. So for example, Mark Drumble has shared some of your intuitions about the developmental view, but his conclusion is that we ought to have a much more sophisticated understanding of what the child is and how we ought to treat children. And one of his reasons, right, and he writes on child soldiering, as I'm sure you know, and one of his reasons is that the way we treat children criminally is just a part of the puzzle. So we want a coherent picture of how we understand children so that the rehabilitative methods and the educational methods and all the other tools we use as a society have the same image of the child as our criminal system. And I find that to be a very persuasive. So, he accepts all the worries about the simple the developmental view, but rejects, but they are bit.
I see. Yeah, I actually don't know why we would need a single conception of the child for all different purposes under law. I just don't see a reason why we would expect or even hope for unification across different domains of law. So in the case of criminal law and criminal punishment in particular, I think that there is a profound need for complicity in the force that the state is exerting against someone to justify that force. That is, we need the he brought it on himself thought. And we don't have that unless we have something resembling authorship over the law. But I think that there's a lot of domains in which we don't need any such thing. So we can conceive of the child for policy purposes as, if we want, as a disabled creature when it comes, for instance, to drinking laws. We end up with some false positives. That is, we deny the right to drink to some people who are perfectly mature enough to get it, and we grant the right to drink to a lot of people who are not nearly mature enough to handle it, right? And that doesn't seem to me to be an instance that implicates political legitimacy in any way that I take to be particularly problematic. Why? Just because we're dealing with something, we're dealing with the conferral of a benefit while trying to manage on the other side a particular set of risks. It's just a different kind of thing from the kind of thing that we're engaged in when we're meting out criminal punishment. So I guess I reject that kind of premise. That is, I wouldn't say the same thing here about other domains. But I also don't see why we need to have unity across domains in the conception of the child.
Just a really quick follow-up to Katerina's question, or rather your response to it. You were worried about giving too much weight to the parents' say over the law, but isn't there an easy fix for that? If you want to give the vote to a 9-year-old, it's still a secret ballot. Parents can talk to their blue in the face to the 9-year-old. Once the 9-year-old goes into the booth, the 9-year-old can do what the 9-year-old wants. I can try to convince my wife to vote the way I wanted to vote. It doesn't work.
Yeah, so
Typically.
it's actually, I mean, the example of your wife is a good one, of course, because there was periods when women didn't have the vote. One of the main arguments that was given against it was, oh, well, but their husbands have the vote. So their husbands can vote for them or something like that, right? But yeah, so I would say two things are getting conflated: entitlement and influence. So you're absolutely right. So you say it's a secret ballot. Who knows how the 9-year-old's going to vote? How much influence do you actually have over the 9-year-old? Like, honestly, how much influence do you have over the 9-year-old without a secret ballot? Like, you don't need the secret ballot to have lack of control. I mean, parents vary massively in how much control they have over their kids' behavior. And this is going to, and so it's not, what we get from the laws of parenthood is an entitlement, perhaps hopeless in its possibility to actually influence children, but an entitlement to do so. And thus what we have is an entitlement to exert influence over the law. That's all it is.
You can just change, but you can change that.
How? Not with a secret ballot.
By saying you can't, well, I mean, why not by just a secret ballot? I mean, you can't forbid somebody from talking to their kid about voting, but I mean, again.
Sorry, the entitlements that I'm talking about go way, way deeper than that. So these are entitlements like entitlement to decide how to educate your child, a legally backed entitlement to do so, right? Where we recognize a whole variety of ways in which the choices of education that you're going to impose on a child have massive influence over the way in which the child might vote. It's those kinds of entitlements, not like entitlements in the moment over control of the child in the voting booth. Now, you're absolutely right. You could change all those. They're contingent. We don't need to give parents control over children in those ways that are relevant to the development of values that matter to voting. You can change those, and in fact, we do change them. They've developed over time in a whole variety of different ways. My point is only that if you're going to really avoid the equality problem, you would need to get rid of all those entitlements in the same way in which we do for the child when the child turns 18.
Okay, hi. So this is kind of a version of, and the first difficult question in a way. So my sense was that you're kind of taking aim at the wrong target. So the problem,
Oops, sorry, I'm listening.
so it seems to me that, that we don't let kids vote because of psychological immaturity. We're lenient to them in the courts because of psychological immaturity. There is this problem of, individual variation, basically. And unfortunately, the law has to, have clear lines. And so it is inevitably going to be arbitrary to some extent where you're going to put the line, right? And of course, the adolescent cases are precisely those sort of cases where you're going to get, precocity on one measure. Of course, that same kid could be a total jerk on another measure. So so that problem again is just a reflection of the fact that the developmental trajectory of human beings, it follows general trends, right? But they're never, perfect. And so, but the law needs a clear criterion. And so it's the age criterion that is the real problem, this arbitrary line. That's the problem. So, the most I could, say is maybe, we need to align whatever that arbitrary criterion is going to be. We need to draw at the same place maybe for the vote and for leniency and stuff like that. But it doesn't follow that both of those aren't dependent on this, psychological maturity, which again there's going to be lots of individual differences. There are, perfect, adults who are terribly immature, So from my perspective, that's, taking, it seems like you've just kind of missed the real target here, which is the problem of an arbitrary distinction that we're forced to draw for something that has such great individual variation.
Good. So I take myself to be taking aim at exactly that target in what I'm calling the problem of empirical dependency. So here's why. So that is, I don't know, you're probably familiar with signal detection theory. So just for others in the room, so signal detection theory says you have a particular method for detecting a signal, like whether or not, so these came from radar originally. So you've got some method for telling you whether or not there's a plane in the air in a particular area. And so the signal kind of goes up if it seems like likely that there's a plane, and you have to, and then the more likely there is to be a plane in there, the larger the signal goes up. But there's also a lot of noise because there's like birds and there's other things that get in the way. And so what you need is some way of deciding a threshold where you're going to say, if it's high enough, if it seems likely that there's a plane in the air, then you're going to scramble your jets and send people over there to fight, for instance. And you set the threshold somewhere on the signal. And you recognize that sometimes you get it wrong. And you can get it wrong in two different ways. These are type 1 and type 2 errors. You can get it wrong because your choice of threshold says there's a plane there and there's no plane there. Or you can get it wrong because your thing says there's no plane there and there is one. Okay? And then you have these two kinds of hits, which is that you can say there's no plane there when there's no plane there, or there's a plane there and there is a plane there. All right. So those are these four categories, two kinds of errors, two kinds of hits. And there's a question about how to set up your devices so that you maximize, you get the best result, the best mix of hits and misses. The more sensitive it is, right, the more of one kind of error you get. It says, constantly saying there's a plane there, but there isn't a plane there all that often, so you get a lot of those kinds of errors. But the other side of it is that if it's really sensitive, then you never miss the planes. Okay? So how you adjust these thresholds matters hugely. So now you can think, and I take it that this is the way you're thinking of it, Carrie. You can think of age as like this. There's signal, and the signal is we want people who are mature enough to be worthy of responsibility being punished. And then you can adjust that age limit, and you're going to get some false positives and some false negatives. You're going to get the four kinds of categories. And the problem is, as you put it, you're always going to have all four categories. And the question is how to maximize, how to get the best mix of hits and misses. And that's the only issue for the choice of age. This is the more sophisticated version than outlined here of, I see it, the developmental view. Now, why do I take myself to be taking aim at it? The reason is because it's well known that from that point of view, you can get better social policies by driving down your error rate and driving up your hit rate. Okay? So it's committed to saying, if we have an alternative social policy, easily implementable, which would result in more hits and less misses, we should adopt it. Well, here's one. Age of 16. 16 is the age of majority for girls, and 18 is the age of majority for boys. That'll get us there. We now have a much better hit rate and a much lower miss rate. Why don't we do that? If you're averse to it, as I am, it's because you're not accepting this position. Here's another example. Some evidence is suggesting that childhood abuse is actually improves development or speeds development in certain areas. Here's a hypothesis. I bet you, on that task with the threat and stuff, I bet you that children who've been hit a lot are better at that task than ones who haven't. I don't know that that's true. This is an empirical speculation on my part, but I'm guessing. So here's a way of driving up the hit rate and driving down the miss rate. If you have a history of abuse as a child, you get harsher punishments. We drive down the hit rate, drive down the miss rate, drive up the hit rate. Not okay with that one? I'm totally not okay with that one. What's this showing? It's showing that our adherence to the policy of lenience towards children is sticky. It's not sensitive to the empirical facts in the way in which even the more sophisticated view that you've outlined is.
Even if I was just going to say, again, I think the most you get is that, if we're going to distinguish by sex or by gender, you know, if that's something we're going to do, which is not what you've argued for, but if one was going to do that, then if we set the line for girls at 16, then we give girls the vote at 16. And if we set the vote for boys at 18, we set the vote at boy, you know,
Oh, I see.
right? So that's all you get, right? I mean, if we want to make that distinction, but of course you didn't argue for a gender distinction so much as just saying, well, that's ridiculous that we should punish girls more.
Oh, good. So fair enough. So that is another alternative, which I think would be coherent by my measure, would be to have a different age for different groups, whether it's by gender or whatever, and also align the voting age to those different groups. I think what you would then be doing would be introducing another form of inequality, which was inequality in say over the law, predicated upon the possession of a particular characteristic that I don't think we want to predicate that on. So it's not. So that's going to be problematic for a different reason from those that are in play here otherwise. So, but you're right. Certainly, from the point of view of coherence, I haven't ruled such a thing out. Oh yeah. No. I mean, you're going to have, for full gender spectrums, you're going to have a lot of questions. Although that's why actually I think in this context it often makes more sense to talk about sex than it talks about gender, because I don't think you're actually going to find developmental differences across all the genders, where you do find developmental differences across the sexes, no matter what gender people assign themselves to. But that's a separate point.
Yeah, we have time for a couple more quick questions, and then we can continue the discussion at the reception.
Sure.
I was wondering if you'd be able to say a little bit more on why it is that entitlement to participate in political systems, whether that's voting or otherwise, is what contributes to culpability rather than causal influence, because it seems intuitive to me that causal influence would be required, because I'm entitled as much as I want to go out and try and stop a hurricane by blowing at it until I'm blue in the face, but it feels like the fact that I'm so impotent in stopping it, that makes me non-blameworthy for what it does. So why is it that entitlement to vote or to participate would actually make a difference?
Good. So honestly, I think you're putting your finger on what may be the hardest thing here, and maybe I'm really just wrong about it. Here's the way in which I'm thinking of it. So first of all, some intuition polls. Start with the Guantanamo Bay one, which I already mentioned. I have no influence, causal influence, but I do have something like complicity. It's what underlies my mortification over those policies in contrast to those of other governments. That's the first point. Now take people who have lots of influence, causal influence, but no entitlement. So, extremely rich Chinese businessman who has all kinds of influence over US elections and US policies and US law in a whole variety of different ways through the spending of money. Such a person commits a crime which, let's assume, is not committed on US soil, not during a status of visiting or anything like that, committed on non-US soil, but which in fact meets the description of a US form of criminal conduct. Criminal culpability there under US law? Of course not. Why? The reason is because US law doesn't provide any legal reasons to behave in this way or that to people who are not on US soil and who are not US citizens. So that is, causal influence isn't going to be enough to create the kind of complicity that matters to the strength of legal reasons. Now, so what these two things together, the fact that entitlement seems as an intuitive matter to sometimes be enough, Guantanamo, and the fact that causal influence is insufficient, this example, is what leads me to think that what matters to the strength of legal reasons is entitlement and not causal influence. Now notice, there's a kind of, what gives me pause about this, or one of the things that gives me pause about this, is that I also feel that there's a certain kind of fiction involved here, which I find a little disquieting, honestly, which is there's this idea of the real entitlement. A real entitlement, where that you feel like maybe you have an entitlement, not a legal entitlement, whatever. Maybe you have entitlement to blow at the hurricane to stop it. But you don't have a real entitlement to do that. And when you start to put that emphasis on real, you start to get the idea of like causal control or causal, you can actually make a difference or something like that. And I don't know how to quiet that thought, honestly, except to say that I feel like my entitlement in the case of the Guantanamo case is real, and it ain't causal, because I have as much control over what's gone on there as you have over hurricanes. That may be the best I can do, and I know it's not fully satisfactory.
So I'm curious about,
Oh, there you are, sorry.
I'm the one with the microphone.
Yeah.
About the role of considerations of autonomy in your argument in relation to evaluations of consequences. And in particular, because it seems that if autonomy is doing all of the kind of heavy lifting in the argument, we would then want to just, in an ideal world perhaps, offer kind of differentiated voting rights and culpability for each individual. So we would go even farther in the direction of the kind of sex differentiation policy that you were discussing with Carrie. So, so then we would just look at the chart and say, okay, well, let's have a battery of tests for each person, and, a precocious 9-year-old gets the right to vote. She's much better informed than perhaps many 25-year-olds, right? And then she also doesn't get leniency if she commits a crime. So I'm guessing that the reason that you would not support going in that direction is because it can easily kind of turn into a kind of dystopia, it's way too interventionist, and so the consequences are likely to end up being negative overall, despite the fact that we, would be perhaps better correlating individual capacities for self-control in a way that enables people to contribute to decisions about the government. And so, I think there's a big arc of an autonomy argument in your, in your view. So can you perhaps?
I see. Well, so it's interesting. I guess I thought of myself as in part pushing away from an autonomy argument, in the sense that one of the things because I don't think that whether or not one gets the vote isn't a function of whether or not one is autonomous or has sufficient capacities to be autonomous, or matching the degree of one's autonomous control over one's conduct. So that is, it's a product of other kinds of political arrangements which are justified for different reasons entirely, which don't have to do with being justified by matching one's say over the law, for instance, to one's degree of autonomy or capacity to do a good job of influencing the law. So that is what I'm trying to point out, is that another way to kind of gloss what I'm saying is there's more to culpability than autonomy. The other thing that matters to culpability is where we set that bar of how much weight you're required to place on legal reasons. And that is not simply a matter of it's not some moral given, but it's in fact a product of the structure of our political institutions, and particularly the structure of the distribution of say over the law.
But the legitimacy argument is an autonomy argument.
So the legitimacy argument is a complicity argument. So the legitimacy argument is it an autonomy argument? Maybe it is an autonomy argument. What it arises out of is the following observation about consent, which is that when I consent to have somebody do something to me, then I make myself complicit in the doing of it to me. And I make it the case that there's an important sense in which I'm doing it to myself. And I take it that's where you see the autonomy idea. And it might be, but it's just that so many people are over the bar of being competent to be complicit in what the government does to them, who we might have good reasons to not allow to be complicit in that way. despite the fact that they're fully capable of it. So the citizens of Mexico, there isn't a one of them who wouldn't benefit from and be capable of having a say over U.S. law and making it the case that U.S. law was something done to them by themselves as opposed to being done to them from without. But we have good reasons to deny them the say over U.S. law. And whatever those good reasons are, they're not coming from some kind of judgment of their lack of autonomy. They're coming from something else. See what I mean?
Yeah, we can follow up later because I don't want to.
I really want to hear what you have to think about this, actually. So, yeah.
Great. That was a terrific discussion, which we can continue at the reception, where there will be lots of tasty food and beverage options. Everybody is welcome and encouraged to attend. Let's once again thank our speaker.
Thank you very much.